This is John Watson. I want to welcome you to another video where we are going through a recent federal court decision. And this is the Payne versus Progressive out of the Fifth Circuit Court of Appeals. And this was from April of this year. And the basic question in this case is when an offer of judgment is made, like was made in this case, does that cause the federal court to lose all jurisdiction or power over the case, and then the case is over? And the court said no, that does not. So let's look at this. So we've got this plaintiff here, Payne, sues under the Fair Debt Collection Practices Act, the FDCPA, and it related to calls. And for the damages, plaintiff requested statutory damages. That's where you get damages even if you weren't harmed. It, in essence, is a penalty to the debt collector and an encouragement to the consumer to bring suit to try to get these debt collectors to stay within the bounds of the law. So statutory damages of $1,000, actual damages, or what we also call compensatory damages. That could be economic, it could be mental anguish, all sorts of things, as well as attorney's fees and costs. So the debt collector, they file their answer, and typically in an answer they deny everything. And then they do this Rule 68 offer of judgment. Now what an offer of judgment is where the debt collector says, look, you can take a judgment against me for a certain amount of money. And if you accept it, you get it. If you reject it, and then later you, the plaintiff, get less than what I, the defendant, offered you in this judgment, then you may owe me some money for cost or expenses. So let's look at what they offered here. They said, we'll give you $1,001 for damages. Now remember, statutory damages under the FDCPA are limited to $1,000 total. That's much different than, for example, the TCPA, which involves automated calls to your cell phone. That can be $1,500 per call. But here it's $1,000 for the whole case. So they said, look, we'll let you have $1,001, attorney's fees and costs as of the date of the offer. Now, there's a huge problem with this offer just in the fact that it's trying to cut off attorney's fees as of the date of the offer, because that's not what the law says. But this opinion actually focuses on this idea of $1,001. So the plaintiff did not respond to it, which is the same thing as rejecting it. And so then Progressive, the debt collector, says, I want to throw the case out. 12b-6 says there's no way the plaintiff can win. 12b-1 says, hey, court, you don't have power or jurisdiction over this case anymore. Now, the court said, hey, you lost that claim because you didn't file it in a timely manner. But I'm going to grant this 12b-1 motion to dismiss for lack of subject matter jurisdiction. And then it said, look, you got all the damages that you're entitled to. But you're probably thinking, well, wait a minute, the person asked for actual damages. You know, that could be more than $1. And the court said, well, you're not entitled to actual damages because you did not plead sufficient facts to support a claim for actual damages. And then the plaintiff appealed, and so the court said, look, here's the issue. Whether that offer of judgment that was not accepted, does that make all your claims moot or require them to be dismissed because the court now has no power over the case? And so the appellate court starts off and it reviews this very well-known principle in law that the federal courts only hear actual cases and controversies, and that's from the Constitution. And so in other words, there has to be some reason for the case. And if you bring a lawsuit and you're offered everything that you're entitled to, then what's the point of the lawsuit? There's really no more controversy. And so then the court notes an incomplete offer. Well, what does that mean? That's one that does not offer to meet plaintiff's full demand So an incomplete offer does not render plaintiff's claims moot. And so if you don't offer the full relief, then the plaintiff has a personal stake. In other words, there's still a reason to have this lawsuit. And so we have a controversy. And so the court points out under the FDCPA, you can get actual, or what are also called compensatory damages. And the plaintiff requested that in 5 different places in her complaint. And the Rule 68 offer did not include those damages. And so since it didn't include the damages, there's a controversy, and the claims are not moot. Well, the debt collector says, and the district court agreed, look, all the plaintiff was entitled to was statutory damages because they did not properly plead actual damages. And the appellate court says, no. Look, you're confusing 2 things. There's the merits. In other words, did the plaintiff properly plead actual damages? And then there's jurisdiction, which is, do you have power to reach the merits of the claims? And the court points out, Supreme Court has said, look, just because somebody files a claim that maybe they didn't properly plead it, that doesn't cause the court to lose power. What you should do if you're the defendant in that case is you should ask the court to throw the case out because the plaintiff failed to properly state a claim. So here's some quotes. It confuses mootness with merits. Prospects of success are not pertinent to the mootness, and the mootness idea is, does the court lose power over the case? And so the court sums it up here. Whether the allegations state a plausible claim for actual damages is different from whether the federal court has jurisdiction to hear the case. And so if you're deciding whether or not the plaintiff has actually pled actual damages, that's the merits. And this is not the proper way to get to those merits. Now, if you look in the footnotes, you'll see the court kind of dodged a couple of issues here because it wasn't necessary. And courts are really supposed to only decide the issues that are necessary, rather than kind of going down a rabbit trail and saying, well, we want to give you some advice on this. And so this was proper for the court to not reach this issue. But one thing the court chose not to reach is the argument, hey, my claims are not moot because you did not offer proper attorney's fees. And the case law, I think, is very clear on that made it a defective offer. And then the court in the second footnote says, look, you can still attack the merits of the case. You just have to do it in the proper way at the proper time. And you did not do that. And here's what the court ends with. What Progressive cannot do is what it attempts to do here. Get rid of all the claims by offering to settle only those claims it deems legitimate. And we see this all the time where debt collectors, they come in to lawsuits that are filed. They say, well, look, we have decided that half of your claims are not valid, so we're not going to give you information on those, or we don't have to deal with those. And we always have to remind them, okay, debt collector or defense lawyer, remember, you're not wearing black robes. You don't get to make that decision. The judge makes that decision, or the jury makes that decision. And we see this also with defendants. They'll come in and they'll offer $2,000, $10,000 for actual damages. And they say, well, there's no way you could ever get more than that. And we kind of scratch our heads, go, well, wow, that's impressive that you know what a jury will do, and we don't even have a jury here. How do you know what my damages will be? And so we point out verdicts that we have received, judgments that we've received in these types of cases for 6 figures. And the defendants hate that, but that's just the reality of it. So they're trying to use these offers of judgment in a way that they really weren't designed to be used. And it's good to see opinions like this one that say, no, you can't do that. Do things the right way and the right time, but don't try to get too cute here. So I hope this has been helpful to you. If you live in Alabama and you have questions about maybe a debt collector's contacting neighbors or calling you at work when you told them not to call you at work, or some other issue that you have a question about, feel free to get in touch with us. Again, my name is John Watts. You can reach us at 205-879-2447, or you can contact us through our website, alabamaconsumer.com. Thank you.